This is the fifth and final essay on the July 2023 California bar exam. It's a difficult session in the exam because it's 3.5 hours long, and you have to judge your time to answer 2 essays and 1 performance test. So it just takes some practice, and my recommendation to you would be that you practice at least 2 or 3 times doing a session like this with 2 essays and a prior PT, a 90-minute PT, in a 3.5 hour block so that you practice getting the timing down accurately. Second essay, let's take a look. Second essay in this session. What equitable remedies does Steve have against Barbara? Equitable remedies generally involves constructive trust and other things. Second call, equitable remedies Acme has against Barbara. So far this is straight remedies, and I am looking for constructive trust. I'm looking for some sort of fraud or misrepresentation. Assuming this is a fraud hypothetical with constructive trust as the main issue, I will come back at the end to review constructive trust and equitable lien and when you would use each one. Third call, what amount of money, if any, can Acme recover as part of an equitable remedy from Barbara's checking account? This is a classic kind of a call that's asking you to explain to the bar what kinds of tracing rules jurisdictions use when a defendant has commingled their wrongfully gotten gains with their own personal money in a checking account. That tells me that constructive trust has to be a huge central issue in this hypothetical. Pure remedies. We get this kind of hypothetical with the tracing rules involved every so often on the California bar exam. It's not one of the most frequent remedies questions, but it does recur. So if you've worked one and you see it again, you'll be in good shape. It's not clear to me whether I should go to our stripped down version of the law now and then read the hypothetical, or vice versa, but I think we will go straight to proponics as a sort of a demonstration of what should be in your mind when you realize this is an equitable remedies hypothetical and you would have memorized this and bring it into your active memory sitting there in the bar exam. So let's go over to proponics. So the remedies schema, we divide it into 2 parts, contract remedies and tort remedies. Under contract remedies, we're thinking about equitable remedies here. So look at restitution. That's an unjust enrichment theory. But more to the point, rescission, the idea that we could undo the contract. The grounds for rescission include fraud, misrepresentation. Reformation, that's an equitable remedy for modifying the instrument, and the grounds include mistake of fact or fraud. But also look at tort, because generally a pure remedies hypothetical that's in the area of equitable remedies is going to be heavily based in tort remedies. So again, look at the idea of restitution. And here you see that we have equitable restitution, including constructive trust and equitable lien. And we also cover tracing rules for commingled accounts. Think about a constructive trust. It's a court-imposed obligation on the defendant to convey specific property to the plaintiff. It's a court order that says, defendant, you did not hold this for yourself. You may have title to the property, but you acquired it wrongfully. And so you are holding it in trust for the harmed party. We have elements, we have the effect of the constructive trust. Equitable lien is slightly different, particularly in that the effect is that the plaintiff has preference over all unsecured creditors, and that the plaintiff can get a deficiency judgment on the rest of the value of his or her claim. So here we're talking about a distinction between whether there's now more property in the defendant's hands or less, and we'll come back to that when we look at the hypothetical. The tracing rules for commingled accounts. Different jurisdictions use different rules. So what you do on the bar exam is simply explain to the grader that depending on the jurisdiction, there are several rules that might be used. Lowest intermediate balance says we look at, in this case, the checking account, and the plaintiff can recover only the amount of funds available at the time that account was at its lowest between the wrongdoing and now. The option rule says the victim can follow his or her money wherever she chooses. So that can follow money into an asset bought with commingled funds, or into the remaining funds in the bank account. That's the option rule. The proportionate share rule says that the victim, lost that one for a minute, the victim gets a proportionate share in the form of a constructive trust. So whatever portion of the account represents the wrongfully gained funds, whether that's 40%, 60%, 80%, whatever it is, that's the amount of money currently in the account that the plaintiff can get. The rule in Hallett's case says that the court presumes that the defendant used his or her money first and that anything left in the account belongs to the plaintiff. Now take a look at remedies for specific torts. And let's assume that we're going to find fraud in this hypothetical and look at the remedies. We have damages. That's not what we're being asked for in our call, so don't discuss it. We have restitution, constructive trust. And that framework is in my mind as I go back to the hypothetical and read the facts so that the issues will pop out. So I see Steve owned property in the state of Columbia that Barbara offered to buy for $500,000. Steve agreed to sell, provided that he retained the mineral rights and had access to the land. So we're dealing with a land sales contract here with two conditions precedent or precedent, however you want to pronounce that. First, retaining the mineral rights, and second, access to the land. Access to the land sounds like an easement, a license, something like that, a profit, because we're talking about mineral rights as well. Barbara later accepted Steve's conditions and said that she would tell her attorney to prepare the necessary papers. When Steve met with Barbara to sign the papers, he asked if the documents included his conditions, and she assured him that they did. So she's assuring him that he has mineral rights and he has access to the land. In fact, Barbara had not told her attorney of Steve's conditions, and they were not in the papers that he and Barbara signed. So the rest of that paragraph is telling you that she quite deliberately decided to defraud Steve. She lied to him. She did not include the conditions. but she told him that she had. So we have pretty clear evidence of fraud. And that allows us to seek the remedy of constructive trust under contract and also under a pure tort theory for fraud. That first paragraph looks to be all we need for call 1 for Steve, but let's see if there's more detail to come. I'm going through here and writing little notes, and I'm yellow highlighting certain phrases. I always do that. I always jot down issues in the margin. I'm always on the lookout for facts that are in the hypothetical that I haven't identified as going to an issue yet, because that would mean in the end that I had missed issues. If I had facts that didn't line up with an issue, then I need to go back and reread and figure out what they do go to and what issue I may have missed. Okay, so here, second paragraph, we have more facts about Steve. Shortly after the sale, Steve decided to investigate whether his former property had any mineral deposits. Barbara refused to let Steve and his geologist on the property and erected barricades to prevent their access. It was then that Steve realized that the documents he signed omitted his conditions. So again, clear evidence of fraud, and from Steve's perspective, a breach. But what we really need to worry about is the fraud. And they're giving us a lot of facts that suggest an easement and Barbara violating the easement holder's rights. So how am I going to use that when we're talking about equitable remedies? Well, I think if I'm going at it from a contract standpoint, one of the remedies I would ask for is reformation. And I'm going to explain to the grader that the contract could be reformed to include the easement or license or profit. Barbara had purchased Steve's property in cash, which included $200,000 of funds that she had embezzled from her employer, Acme Company. So here we go with call 2. Barbara has embezzled what are Acme's remedies. So she put $250,000 of Acme property, Acme funds, into the real property that she bought. So they're going to want a constructive trust over that property. Barbara later embezzled another $20,000 from Acme, which she deposited in her checking account containing $5,000 at the time. These facts about the $20,000 and that she had $5,000 at the time, that goes to call 3, to the tracing rules. The following month, she paid off $25,000 of her outstanding debts, bringing her checking account balance to 0. So she spent all of Acme's money and hers. Then she deposited $10,000 of her own money into the checking account, and thereafter Acme fired her after discovering her embezzlement. So that last paragraph goes to calls 2 and 3, remedies against Barbara for Acme, and the tracing rules that tell you how much of her checking account Acme can recover. So think back to what we looked at in the schema and realize that in call 1, asking for equitable remedies Steve has against Barbara, We can discuss restitution, we can discuss rescission, we can discuss reformation, we can discuss the fact that the remedy for fraud would include constructive trust and equitable lien. And under that reformation discussion, as I said, I would talk about the fact that the contract could be reformed to include Steve's easement, his profit, his license. It could include both of his conditions. Call 2, equitable remedies Acme has against Barbara. Here again we have constructive trust and equitable lien. The court could impose a constructive trust over the real property. What about equitable lien? Equitable lien is really useful when what the defendant holds now is less than what he acquired as wrongdoing. So if you think about that $20,000, not the $200,000 that she embezzled to buy the property, that is fairly straightforward. The $250,000, that's fairly straightforward. Constructive trust over the real property. But think about the rest of paragraph 3. The other $20,000 that she put straight into her checking account along with $5,000 of her own money. She spent all of it to pay off a debt. So her checking account went to zero. Under one of those tracing rules, lowest intermediate balance, Acme could get nothing from the account because the lowest intermediate balance was zero. Under the other rules, Acme could presume that she spent her own money first and get the entire $10,000 that was currently in the checking account, or follow the other rules to come to the conclusions that each would bring. Now, I know it takes time to write those up, but if you've really well memorized them, you can make very short work of that. And so call 3 would be pretty straightforward. So there are several places here you can raise constructive trust. You can raise it in call 1. You can raise it in call 2 in 2 different places. For the $250,000 originally embezzled that she used to buy the real property, and also for the $20,000 that she embezzled. But there, equitable lien is probably the preferable remedy. If you're raising an issue like constructive trust more than once in an answer, you don't have to go through all the elements and review the law every time. Refer back to your first analysis of constructive trust. So now, go back and think about constructive trust and equitable lien. Constructive trust allows you, as the plaintiff, to get any appreciation in value. And it requires the defendant to transfer title and possession. The creditors have no claim against the property. The plaintiff gets it flat out. So if the property is intact, if what was wrongfully gained by the defendant has kept its value or has increased in value, then constructive trust is preferable as a remedy. But if there is no longer sufficient value in what the defendant holds to compensate the plaintiff, to pay for the wrongdoing, to disgorge the unjust enrichment, then look at equitable lien, because the effect of that is that the successful plaintiff has preference over all unsecured creditors, and that he or she can get a deficiency judgment on the rest of the value of the claim. That's incredibly useful where there's depreciation. Thank you for sticking with me till the end of this. And if it's been useful to you, please tell anyone you think would be helped with our YouTube channel and our debriefs of these essays. And it would help me a great deal if you would leave comments and if you'd subscribe to the channel and like the video. We're trying to get the word out about what we're doing here.